As she said, my name is Charisse Fano-Burdine. I'm the Chief Operating Officer at the Pretrial Justice Institute, and it's my honor to moderate this panel this morning. I hadn't thought about this before Nicole said that this morning, but I will tell you what brings me to this issue. My first name is Charisse, and the only other Charisses I've ever met in my life are African American. I grew up in a small town in Ohio, and when I was in college, someone said to me, "Why do you have a black name?" I didn't know names were of particular color. I didn't know if I had a green name or a red name. And I said, why would you say that? And they said, that's a predominantly black name, and you don't even spell it right. That really stuck with me, and sometime later I began applying for jobs after graduate school. I walked into an interview one time, and the interviewer was surprised, I think, at my color. And she honestly said this, "Oh, wow, I didn't expect this." And I said, "Expect what? This incredible beauty sitting before you today?" She said, "Oh, no, I just had never heard your name before." And I knew what she meant. My father always taught me growing up, if you just work hard and you play by the rules, everything is fair. And it didn't take me long to realize that that wasn't true, regardless of the fact that my first name, which is French, which doesn't matter at all, and also that it mattered to people. When I was interviewing, it mattered to people. Where I lived in housing, it mattered to people. And that always conflicted for me with what my father had told me. And now that I work in the criminal justice field and have for a long time, it's that fundamental sense of unfairness, regardless of it's black, white, brown, white, Asian. Everybody should be treated the same, and everybody should be treated better. So that's what brings me to this issue. I'm going to take a moment because we're being filmed, I'd like to actually introduce the speakers today. That's an impressive panel of people. Immediately to my left is Cynthia Jones. Many of you may know Cynthia Jones. One of the most important things about her, of course, is not in her biography. We'll have to change your little bio. She's currently an associate law professor at the Washington College of Law. She teaches lots of interesting classes. She, prior to that, in other lives, has been a public defender. She currently serves on the Public Defender Services of D.C. board. She's also on the Pretrial Justice Institute board, which is what's missing from her bio, the place where I work. She has recently, we're about to publish, is it out? About to publish an incredible piece of work on the impact of race and bail, and so she's going to be speaking predominantly today from her paper, and it's very exciting. Very, very proud of that paper, and I'm proud for you to be associated with PJI. To her left is Spurgeon Kennedy. The most important thing, of course, on Spurgeon Kennedy's biography is that he's the vice president of the National Association of Pretrial Services Agencies. I'm also on that board, and we work together on lots of issues across the country related to technical assistance and training for pretrial officers. Kenny also spent time at the National Institute of Justice, which is the research office for the Department of Justice. He works at DC Pretrial here in the District of Columbia, and is an all-around terrific guy and brings a lot to this issue. I'm sorry, sir, have we met? That's my boss. I know he's mad I'm taking up his time. That's Tim Murray. He's the executive director of the Pretrial Justice Institute. Tim comes to this issue. I noticed his bio said 40 years of service. He's the principal architect of drug courts in Miami and came to the Department of Justice to help when the Justice Department set up the Drug Court Program Office. You know, there was lots of controversy around drug court. There are also a lot of people getting clean out of drug court. Tim also was involved in the DC Pretrial Services Agency back in the beginning, maybe not the beginning, and has also spent time at the Bureau of Justice Assistance at the Department of Justice. He's been all over the country talking about pretrial justice and bail issues for the last 10 years. Should be credited with putting the issue of pretrial injustice on the radar of organizations such as NACDL, and we're very grateful for their partnership on that issue. So with that, I welcome our panel. We're going to start with Cynthia. Is that right? Great.
So I'm going to move to the podium here. So we have a film clip we were going to use. Is that queued up?
I do see that the cargo weight changed. They reduced the poundage, I'd see. That is all. It's simple, ghastly arithmetic. Well, for you, perhaps. I may need a quill and parchment and a better imagination.
And what poundage do you imagine the entry may refer to, sir? A mast and sails, perhaps?
Give us free. Give us free. Give us free.
Please instruct the defendant that he cannot disrupt these proceedings with such actions.
Give us free!
If we are to have any semblance of order in this court, Your Honor.
Give us free! Give us free!
Keep crying out, give us free, or anything else.
Give us free!
I'm trying to question this witness.
Give us free! Give us free!
So some of you might recognize that clip from the movie Amistad. If you've seen the movie, you know that most of the movie was focused on a group of African slaves and who owned them, the civil suit regarding who owned them. But in fact, when I began to research it, that scene actually did play out in a courtroom, and it played out in the context of the criminal charges that the slaves were facing for slaying their captors. And they had been held in a period of pretrial detention while all of the legal issues were worked out in terms of who owned them civilly and whether they were going to be charged and where they could be charged. The frustration, the incredible frustration of these slaves who did not speak the language, begging for freedom, in many ways mirrors the frustration of the bail system and the racial disparities in bail. Two things about that movie are particularly poignant, and one is seeing groups of black slaves, black men, bound and shackled together and herded into a courtroom to decide for a decision to be made about whether they're going to be released or held. That same scene plays out in courtrooms all over the country. Groups of black men shackled together and brought into arraignment court for a bail determination. The second thing that's so poignant is this notion that in our criminal justice system, we are still making decisions about release or detention, and that those decisions are being influenced by race. So there are a couple of things that we know for sure. We don't need any additional studies. We don't need any additional research. For the past 40 years, there have been over 30 studies, local studies, national studies, studies of juvenile court, federal court, state courts, and the studies conclude that African American defendants are subjected to pretrial detention at a higher rate than similarly situated white defendants. And when bail amounts are set, a monetary bond is imposed, across the board, African Americans receive a higher bond than similarly situated white defendants. That is, they're facing essentially the same charges, they have essentially the same background in criminal history, but African Americans are more likely to face worse outcomes at bail determination proceedings. One researcher said, being black increases a defendant's odds of being held in jail pretrial by over 25%. Now, the questions we need to ask, first of all, is why are there racial disparities in bail determinations? And how do we fix it? But preliminarily, why do we care? Why is it so important? Bail's at the front end of the criminal justice system. It's not a guilt determination. It's not a sentence determination. Or is it? We know from the research that if you are denied bail, or if you are in any way receive a bail that you cannot post and you cannot get out of jail and you're held in jail pretrial, you are more likely to be convicted. In essence, the decision that's made on bail dictates the adjudication trajectory of the rest of the case. You are more likely to be convicted. You are given a worse plea offer. You're more likely, once sentenced, to receive a sentence of incarceration, and you are more likely to receive a longer sentence if you were held in jail pretrial. It is much easier, any defense attorney will tell you, it is much easier for a judge to keep a person locked up if they're already held than it is to lock somebody up who's coming in from the street. So the bail determination is critical, and it basically dictates how we proceed. So the first question is, why are there racial disparities in bail? There are several reasons. One of the most important functions that happens at the front end of the criminal justice system is a determination of what to do with these arrestees, these new defendants. And the purpose of bail, for those of you who haven't studied the system for years and years, as some of us have, is really twofold. You're to decide whether the person is a flight risk. Are they likely to leave the jurisdiction and not come back for the rest of the proceedings? And whether the person is a safety risk. Are they likely to, if we release them today, pending trial, to go out in the community and retaliate against the victim or threaten or intimidate witnesses? That flight safety risk determination has to be made, and the judge is trying to decide how to manage that risk. When they're making a bail determination, how do we manage that risk? If we make you pay $10,000, will you not recidivate? Will you not go out and flee the jurisdiction because you'll lose the $10,000? If we put you in a drug treatment program, will that stop you from reoffending or stealing something to buy drugs? The judge is trying to manage that risk. One of the big problems that we face at the front end of the criminal justice system is, in order for the judge to make an informed, educated decision about how to manage that risk and who should be released and who should be detained and what the conditions are, they have to have information. Most bail statutes mandate that judges take into account the obvious things: the prior criminal record of the defendant's prior failures to appear in court, ties to the community, their resources. All of those things should be taken into account, and all of us would want to take those into account. If I'm trying to decide whether you're a risky person and I shouldn't impose bail or should hold you in jail, the fact of the matter is, in most proceedings across the country, judges do not have adequate information to make that informed decision. The police arrest the person, the prosecutor decides to charge them, the defense attorney perhaps gets appointed, and in many cases is not appointed at that first court appearance, and so the defendant shows up and the judge knows little or nothing about them. They know a few things: what they look like and what they're currently charged with, and they might know whether they have a criminal history in that jurisdiction. They don't know if they have an outstanding warrant in Texas. They don't know if they're lifelong residents of that jurisdiction, college-educated, military veteran. They don't know, and they don't ask, and no one checks. So in the absence of that information that's so critical to making the bail determination, a couple of things happen. One, there's a knee-jerk, reflexive reaction to simply impose a monetary bond in some arbitrary amount. I don't know whether $500 is going to keep you locked up for 4 months until trial or whether you could post that $500. I'm not asking, and I'm moving things along. So the monetary bond system is one of the things that causes racial disparities because poor people, and it has a disparate impact on minorities, poor people can't make bail, even the most minimal bail. The second thing that happens, and psychologists have looked at this and social scientists have looked at this, in the absence of the relevant key information needed to make an informed bond decision, what judges and bail officials do is rely on the only information they have before them, the charge and what the person looks like. And race becomes important. We don't have to guess or wonder or speculate about whether race influences bail determinations. We have 40 years of studies, national and local studies, telling us race does in fact impact on exactly what the judge is going to do. The other things that impact that decision is the fact that there are so many cases on the calendar, judges are making this decision quickly, and there are very little restraints or guidelines to rein them in. So they basically get to make whatever decision they want to make. One legal scholar, Professor Marsha Johnson, says, the broad breadth of discretion that judges have makes it easier for them to improperly consider race, even in an otherwise race-neutral bail system. For example, a judge may determine that a defendant is dangerous simply based on his or her stereotype of what a dangerous person looks like, which in some cases might simply mean that the defendant is African American and male. So several studies have examined this issue, and here are a few facts about race and bail. One, white defendants are more likely to be released on their own recognizance. That is, no money bail required, no conditions. We release you on your personal promise to return. I worked on a study in Duluth, Minnesota, and in Duluth, that study showed that whites were twice as likely as other racial minority groups to be released on their own recognizance. All things being equal, same charge, same criminal history, twice as likely. We know from the studies that when money bond is imposed on both white and African American defendants, African Americans, same charges, same criminal history, receive a significantly higher money bond. Again, the study that I worked on, the median bond amount imposed was double for African Americans than it was for white Americans, same criminal history, same charges. And these studies, which date back to the 70s, even the ones since 2010, continually repeat that same pattern. It's been consistent. If you are African American, you are more likely to be held, and if you get a bond of any amount, it is likely to be much higher. You pay more for your freedom than would a person who is white. Now, my colleagues on the panel are going to talk about some of the systemic reforms and how to fix the bail system. But I want to talk a little bit about some of the things that can be done within the current scope of the bail system. It may be hard in a particular jurisdiction to get them to change their bail statute, to overhaul the way they do bail, to create a pretrial services agency like the one where Spurgeon Kennedy works in DC. It may be hard to do that. It may be next to impossible to garner the resources and political support to do that. But there's so much that can be done within the scope of the existing bail system in most jurisdictions. First and foremost, courts allow non-lawyers to make bail determinations. In Maine, the judge appoints members of the community. And a study looking at that system in 2006 said some of the people who are making bail decisions are reporters, maintenance men, people who work in the insurance industry, and they've received no training on the Eighth Amendment, the bail statute. They go in, they hear what the defendant has to say, the defendant's unrepresented by counsel, and then they just make a number, $5,000, and that's it. And we know that that decision, regardless of the jurisdiction, is rarely appealed by the defense lawyer once he or she's appointed, and it's rarely changed by the reviewing judge, even if there is an appeal. So basically, that arbitrary decision that was made at the beginning continues to haunt the defendant throughout the life of the case. We know also that even in Baltimore, you are unrepresented by and large at your bail determination hearing. You go in by yourself and you have to make your best pitch for bail. And it's not a judge you're making your pitch before. It's someone appointed by the court, and most of them are not lawyers. You sit in a cell and you talk to a person through a glass, and they have some information about you, and they get to make up a number. In a 2009 study of the Baltimore system, the officials found there's really no rhyme or reason to what bail is set for what officials. It is completely arbitrary. You can't say for simple assault you're more likely to get $1,000 bail, or for aggravated assault $10,000. It's random and it's arbitrary. So the first thing that could be done to fix this system is to rein in the bail officials. Right? Either have judges make the decision, or at least put some constraints on bail officials and provide some oversight and accountability. Specifically, why not ask or demand that bail officials articulate why they are imposing bail and exactly what it is that you know about this person that causes you to believe they're dangerous or flight risk. Simply asking them or mandating that they articulate it is going to force them to say, well, because he previously threatened the victim or because he has no ties to the community. And if the bail official is making this determination based on no information or relying on race, I think very few, if any, bail officials would say, well, it's because he's black. I just decided to do this because he's black or because he's Latino. It would force them to stop doing what we know they're doing, and that is using racial stereotypes and implicit bias in this void of, to fill this void of information that they don't have, relevant information they don't have. So another change that I think would help is accountability. One of the things we know about implicit bias that we didn't know before is that informing someone about their biases, educating them to a pattern of disparity, impacts how they behave. Knowing, for example, that if you look, we looked at all of your bail decisions, magistrate judge, bail commissioner, for the last year, and we noticed you tend to lock up more African Americans. That is, you impose higher bails on them. You impose more stringent conditions on them. We wanted to make you aware of that. Currently, in most, I would say nearly every criminal justice system, nobody is looking at the impact of the bail decisions being made. No one's examining them and looking and reviewing them to see whether there are patterns of racial disparities. Usually there's a lawsuit or there's something that happens and that sparks a review. But regular reviews of these bail determinations, what the research on implicit bias says, once you tell a person making discretionary decisions that there is a pattern of racial disparities that emerges from their work, they change the way they do business. Nobody wants to be viewed as a racist. Nobody wants to be viewed as engaging in racial profiling or disparities. It changes them. And I would propose, as a policy matter, there's nothing that legally prevents the court system from saying, we're going to have a bail review committee from all of the criminal justice stakeholders, and we're going to be pulling those bail decisions. One, we're going to be looking to see what the justification is. That is, that it's tied to safety or flight risk. And two, we're going to be reviewing those bail decisions to determine if there are patterns of racial disparity, and we'll be reporting them back to the bail officials. That level of accountability, I suggest, as a minimum, is a starting point for getting at the racial disparities in bail determinations and eliminating them. At a minimum, it makes the criminal justice system more accountable to the individuals who are detained. There are other areas where we can explore and talk about how to fix the bail system, but I don't want to hog the time, and I want to make sure my co-panelists have a chance to speak. So thank you very much.
Good morning, everyone. I'm Tim Murray from the Pretrial Justice Institute. I'd like to thank the organizers for hosting this event and for inviting me to it. I'm in awe of my other panelists. They know so much more about this stuff than I do. And you would have a wonderful presentation without the few minutes you're going to have of me, but oh well. First thing I think is a question that has to be addressed. Was anyone else curious when Norman said he chose not to have long hair? I mean, I'm in this cone of truth, Nicole. I'm not a big fan of lower bails. It's not the problem. I invite you to join me in my bewilderment of why on earth we have the system in place that almost all of us accept as being in need of tweaking, if not to support racist, classist protections and policies. Why on earth would we have a system in place? I am not talking about a few judges who have a bad attitude. I'm not talking about bail commissioners who are plumbers. I'm not talking about a region or a county or a state. I'm talking about this republic that predicates the most important decision that is going to be made in a criminal case on money. On money. What the hell is that about? Who has money? Who doesn't? So we get sidetracked into these conversations about it's too much money, it's not enough money, all these other things. But who has money? You got money. Bernie Madoff has money. Martha Stewart has money. Lindsay Lohan has money. They get arrested, they give away tons of money. Does that mean Lindsay Lohan is of low risk and can be accepted back into the community with some reasonable assurance that she can continue to misbehave? No. It means one thing and only one thing. Lindsay Lohan's got money. This morning, as we sit here, 2 out of every 3 prisoners in your country's jails are there simply because they don't have the money to buy their way out. Money. What the hell does money have to do with justice? What does money have to do with getting me back to court and keeping you safe from my misbehaviors? Anybody, show of hands, help me. Money really doesn't do any of those things, does it? Why the heck would we have money? I know. Money does do one thing really, really well, doesn't it? It separates those who have it from those who don't. The most severe sanction the state can impose upon you, short of killing you, is to put you in a cell, deny you your liberty. And so we say to every single arrestee, we are imposing the most severe sanction the state has at its disposal, unless you got some money. Because we know who's got money, and we know who doesn't. I've done this kind of work for a big part of my life, and I came to the conclusion a long time ago. The reason they use money is because they know the defendants don't have any. The reason they use money is they know that I do, and if my kid gets arrested, everything's going to be just fine. We will hear people tell us, well, we need money because there are dangerous individuals who are accused of crime, and while although presumed innocent, these are some pretty scary guys. Recent research that has just been published this month, and I urge you to read it, by the Laura and John Arnold Foundation, it's on our website, pretrial.org, shows that most of the most risky defendants, risk being defined as rearrest and flight, most of the most risky get out. It also shows that most of the low-risk defendants, risk being defined as flight or rearrest, are detained. And just as an added bonus, the simple act of detaining those individuals statistically increases their likelihood of recidivism when compared with identical groups who are released. So we've got a system that does a crap job of slowing down dangerous defendants. It makes low-risk people high risk. And yet when we talk about it, we talk about, there's too much money being used. We need to use less. We need to abolish this hypocritical, dangerous, and unfair practice. We need to say out loud, over and over again, enough. It is unsustainable, indefensible, tragic, and toxic. It can be changed. Because we want to fix it, we don't get a pass. When I was a kid, my first indoor job, and I had long hair, Norman, and served in Vietnam, was in the criminal courts here in D.C., before it even was the Superior Court. That, as I recall, and listening to people's own personal reflections, I thought I was a pretty worldly guy. I had been in the Marine Corps. I had been in a war. I had hitchhiked cross country. I had been arrested. I was a pretty salty guy until I got to the Court of General Sessions. And then that environment just took my breath away. Never seen anything like that. Never saw so many white lawyers, judges, prosecutors, defenders, marshals, courtroom clerks, and so many black defendants. And I was part of an organization that was reformed, DC Bail Agency, which became where Kenny now works, the DC Pretrial Services Agency. And we were going to fix this money thing. Money's unfair. We're going to chip away at that castle. And so what we're going to do is we're going to put into place instead community ties. And so we don't care if you have any money. All you need to have is a stable residence, one that we can verify, people that we can reach in a matter of a few minutes, because court's going to start soon, on the phone, on a working phone, obviously, that will vouch for you and tell us where you live. Of course, you got to have a job, right? It's got to be a real job, steady job. You can't have been in much trouble in the past, please, because that kind of shows us who you are. No drug or alcohol problems, if you might. And we need to make sure that you have at least 3 individuals that you know their name, address, and phone number. What? So you haven't even described me. I can't give you 3 people's name, address, and phone number, right? Who can give anybody's phone number anymore with cell things? But we believed to our toes we were fixing things. We weren't fixing things. We described the appropriate risk around a middle-class white guy's attributes. We are now evolving away from that reform into one of risk assessment. Scientifically validated, proven risk assessment. Risk assessment, if we're ever to throw money bail in the toilet, it will be because we've been able to convince policymakers of not only the dysfunction of all of this, but because of the efficacy of risk assessment. With risk assessment comes a whole new set of issues. Will risk assessment contain inherent biases, regardless of its motivation, regardless of the motivation of me and my friends in the 1970s in Superior Court? Will the outcomes be just as bad as they are today? Because if that's the case, then we have literally, even with the same numbers, we have literally made things worse because we've now painted ourselves in the colors of reform. Advocating reform isn't enough. Making change is what's required. Taking the hypocrisy of money and blowing it out the window does nobody any good other than a little self-gratification if we replace it with something just as ineffective and just as toxic. I've worked in enough justice systems to understand they're pretty nasty critters. They tend to be mean-spirited, despite the wonderful people who work within them. They tend to find ways to punish those least able to protect themselves. They tend to have outcomes that take your breath away. But they're built on a blueprint that's so beautiful and so inspiring, that touched me when I was in 9th grade civics and somebody taught it to me the first time, and it still gives me goosebumps. Join me in restoring a system that gives all of us goosebumps wherever we go in this country. Thank you.
Good morning.
Morning.
And welcome to those of you who aren't from the D.C. area. I am. And going with today's theme, yes, I used to have long hair too. Okay, wasn't that funny, guys? Unlike Charisse, I didn't grow up with a black name, though. Spurgeon is not something you really hear a lot in inner city D.C., but we make the most of that. I am from D.C. Those of you who know people from D.C. will know that we don't do humble very well. And I'm here to tell you that you are in the city with the best bail system in the country. Thank you. Come on, you can clap. We'll talk about that, and one of the things that comes out of that has come out the last decade or so, and Tim and Charisse really deserve all the credit for this, is this thing called pretrial justice. This idea that reform of the bail system is not on one particular actor in the bail system. I am a pretrial services program. We interview defendants. We assess their risk. We supervise them while they're out on community supervision. We report back to the court about compliance and non-compliance. We connect defendants to services, substance abuse, mental health, community-based services as needed. We do all these great and wonderful things, and we are not the reason why our rates are what they are. Pretrial justice as a concept means that everybody who is in the front end in decision-making, prosecutors, defense attorneys, judges, pretrial programs, police, everybody has a responsibility to make that reform real. In Washington, despite our great and wonderful bail system, we are as racially disproportionate as everyone else when it comes to criminal justice. D.C. has a population that is 50% African American. That is a 15% drop from the 1990s. Our criminal justice system is 80% African American. You may have heard some studies recently, marijuana, possession of marijuana, which is a very popular charge here in the District of Columbia for some reason. If you look at drug use patterns across the city, most people will tell you that there shouldn't be a big difference racially. Yet 9 out of 10 defendants who are charged with possession of marijuana in D.C. happen to be African American. We do have a racially disproportionate arrest population, and that feeds into our criminal justice system. My job as a pretrial professional and my job as a member of a good, functioning, progressive system is to make sure that that disproportionate representation isn't further violated by bad decisions that play up race. So how do you do that? First off, you recognize that this is a system-based approach. So I'm going to go over some things that we do locally that get us a fairly good result. Start off, though, with some numbers, because I'm a numbers guy. It's what I do for a living. 90% of the people who come through the D.C. system are going to get released. And they're going to be released either on their promise to come back to court, or they're going to be released on some form of conditions. Tim mentioned money bail, and how if you just got rid of that, you would go a long way to making a fairer system. We don't use money in D.C. Let me repeat that. We don't use money in D.C. Think of any kind of charge. Think of any defendant. Think of any circumstance, first-degree murder, petty theft, that case that gets into the Washington Post and upsets the entire community. Every single one of those cases come before a judge for bail. And in all the time that we've had here, we have never decided that money is the best way to handle those situations. 18,000 cases were filed last year. Fewer than 800 had a financial bond associated with them in the district. You don't need money to have an effective pretrial system. Anyone tells you do, they don't understand what true risk is and how to do bail well. First step, you do need an assessment, as Tim mentioned, that takes you away from looking for every single middle-class defendant in your population, because you ain't going to find any, okay? Go away from those things that, okay, if you look like me, I can safely release you. No. Release has to be based on factors associated with failure. Many pretrial programs are moving towards validated risk assessments and are seeing a much fairer distribution and recommendations. My jurisdiction recently validated our risk game for the first 3 months or so of the data that we looked at. If you control for other factors such as outcomes, actual failure to appear in rearrest, prior criminal histories, current status of the criminal justice system, if you hold all those things constant, you will find that release rates among African American, white, Hispanic defendants are the same. Using validated criteria will actually help you reduce the effects of that disproportionate representation, because you're no longer basing your decisions on things that carry a racial disparity in the first place. Second, you've got to have multiple release points. If the only place that you can release someone is in front of a magistrate with college education, no law school experience, then you're screwed. Sorry, you are. In D.C., we try to develop multiple points where persons can be released. My agency is working with the United States Attorney's Office, our Office of Attorney General, and our Superior Court to develop criteria for non-custodial arrest. Most people get into our systems not because they're charged with anything major, it's because they are charged with minor offenses, misdemeanor charges, city ordinances that bring them into the criminal justice system. If you can take those cases and stop arrest being the only thing that a police officer can do, you greatly reduce detention rates. We are making citation releases, we're making cite and release, we're making fines much more common in those low minimum risk cases than we have made them in the past. Okay. Sound good so far? Good, glad. On the right track for once. Money, get rid of it. Seriously, get rid of it. As I said before, only a handful of cases that we have are based on money. Last year, to the best of our knowledge, and our DC jail might disagree, but I think we're better at data than they are, we only found 160 defendants throughout the entire year, throughout the entire fiscal year, who were detained pre-trial simply on a money bond that they could not post. That's 160 defendants out of 20,000 defendants who had open cases last year. You don't need money. What you need is a system of release that allows you to supervise those defendants who need supervision, and there are a few that do, and also a system that allows you to detain those defendants who are truly dangerous defendants. There are two things in our bail law that make things work in D.C. One, we have a preventive detention statute. If you are truly a dangerous defendant, someone whose release will pose a threat to the community, there's a statutory way that our courts have to detain you. It isn't, okay, $50,000, gee, I hope that keeps you in jail. A judge has a way by statute to clearly identify who a dangerous defendant is and to hold them pretrial. They also have the ability, if you're the defense, to argue that that detention isn't necessary. Last year, of the people who were initially detained by our statute, 55% were released once that hearing was held to show whether or not this person truly was a danger. So very few defendants in D.C. stay detained throughout the process, but you have to have a process that makes that designation possible. Second, you got to take money away from judges. Sorry, you just have to. We, unlike other jurisdictions in the country, have not outlawed money bail. A judge can write a surety bail here in D.C. if they want to. They just don't. There's a part in our statute that says if you use money, you cannot make money a detention when it comes to safety, and you can barely use it to make it for appearance. If you set a money bail in D.C. within 48 hours, that defendant is right back in front of you, and you've got to reconsider that bond. You do that enough, it becomes a hassle for judges. They don't want to do that. So they think of other things to do, and hey, look, there's this pretrial program over here that supervises defendants and makes these wonderful recommendations that maybe we should start listening to. Last year, 3,000 defendants in D.C. were released on a promise to come back to court. No conditions at all. 18,000 people got released in D.C., no conditions at all, not a cent of bail. Every single one of them made their scheduled court appearances. Not a single one of them was rearrested for a new charge pretrial. That's your defendant population. You have a low to medium risk defendant population, white, black, Hispanic, whatever, and you need to start treating them that way. If you get away from the racial distinctions and make this a risk-based decision and have things in place that make sense to judges and defense and prosecutors, you can have an effective bail system. So reform is possible. I hate thinking that we're Disney World in D.C. We can be a jurisdiction like any other jurisdiction. It's simple. There are things that you can do, things that we would love to talk to you about. So thank you.
So we have a decent amount of time, about 25 minutes for questions. Folks have questions for our panelists? Do you want to? The microphone is going to be coming your way momentarily.
Can I ask a question while we wait for that? Because the people who know me know I'm loud enough. So.
I think they want it recorded.
Oh, we're being recorded. Here's
Yes,
a
ma'am.
Here's a mic. Thank you. And Cynthia, this is a question for you and any of the other panels, but specifically it came to mind when I was listening to you. When you talk about bail and you say, you know, one of the factors that they obviously have to consider other than the charges is simply race. When any of the studies that have been done, do they control for economic status such that if me, several degrees, black attorney, make X amount of money, does it make a difference if I show up in someone's courtroom versus another African-American woman who does not have those same advantages?
Yes and no. So there was one study of federal courts looked at about 30,000 cases, and they determined that social economic status made less of a difference for African Americans than it did for whites. So if you had an African American professional and a white professional, both of whom had college degrees and education, you were still more likely to be detained than was the white arrestee. So it won't make a difference, or it'll make less of a difference in that scenario. But vis-a-vis another African American woman who doesn't have the same socioeconomic status, I haven't seen studies on that. I think you both would be treated more harshly because in all likelihood, the judge wouldn't know that background. If the judge is in the situation where in most jurisdictions, they don't have information that you're a lawyer, they won't know that you're college educated. They will look at you and see an African American woman and look at the charge that you're facing and make a decision based upon that. And so unless there's a risk assessment, unless there's a pretrial services report being prepared where the judge can say, oh, wait a minute, she runs the Brennan Center and she's graduated from college and she's got ties to the community, there would be no reason for me to impose a money bond, one that she might not be able to make, or impose conditions on her versus this other person who doesn't have the resources or the stability. So it all depends on what kind of pretrial system exists.
Now, I don't want us to take a pass. I apologize for being so cranky this morning, but I'm among people that I'm allowed to be cranky with. When I talk to other folks, I have to be much more polite and much more subdued and all that other stuff. So don't think I go around the country, doing the stuff I did up there, right? Up until very recently, we could all nod our heads and say, gee, the DC system's really cool. Wish we had it, but we don't have any money where we live, right? These new risk assessments that have been emerging over the last couple of years that are pretty precise, and as Kenny says, for the most part, race neutral in terms of elevating release rates among demographic cohorts, don't require a pretrial program. They can be built into existing information technology infrastructures. They are based on factors that don't require a pretrial interview. Every community in this country has a probation department. They supervise people. Resources are there. The will to use those resources rationally, safely, and even-handedly is what we need to help develop.
Great, thanks. I think we have a question in the back. Would you please introduce yourself?
Yeah, David Merriman, National Criminal Justice Association. So you made a great point earlier. With the understanding that money does move politics, what is the messaging around pretrial bail reform? And are there any lessons that you can take from the reform that has occurred with the paycheck and cash advance folks? Because I feel like they're the same folks.
Yeah, that's a fascinating point about the paycheck cashing folks and the bondsmen. There's a general a general understanding that that's the same family of folks. Unfortunately, when we have conversations about money, it often veers over to bondsmen, a uniquely American, a uniquely North American character. Bondsmen don't exist anywhere else in the world except the Philippines. But it's a mistake when we talk about bondsmen because bondsmen aren't the issue. I'm convinced to my toes, we are the issue. Bondsmen are simply profiting from a system that on its face slaps the snot out of the disadvantaged and treats everyone else with dignity and respect. And unless and until we go after that systemic design, the people who profit from it, will continue to profit from it. As long as we go after colorful bondsmen and their shady practices and all the nefarious nonsense that occurs within that industry, I worry we are distracting ourselves from the core issue. And that is, we build the release of the accused on this hypocritical premise that we know statistically doesn't work, we know statistically is dangerous and causes harm, yet we embrace it, and it's almost impossible to pry our fingers away from it. Remarkably, we've done national polling. We haven't done it. We have a foundation that works with us that's done national public opinion polling for the last 2 consecutive years. And in that polling, we asked the respondents, would you rather have risk assessment or use a series of dollar amounts to determine who gets out of jail and who stays in? And the response across the board, both sides of the aisle, all demographics, what the hell are you doing now? Well, now we have a list of charges and a list of dollar amounts. It's like a menu. It's a laminated card in most courts, and whoever it is reads from that card. And the public response is, why are you doing that? We thought you wanted us to. Isn't that being hard on crime? No. That is ensuring the least advantaged are staying where we want them And that is ensuring that we can make that happen while at the same time, one of your kids, one of my kids get in trouble, don't worry about it. We'll treat them rationally. We'll treat them with dignity. We'll treat them with respect. We will treat them as though that ninth grade civics chapter, whose header was equal justice under law, is in fact a reality.
Other questions? Norm?
Thanks. Well, I want to direct my comments to you, Tim.
I knew I was getting the hair.
First of all, I want to thank you for reminding me that I am living proof of the old adage, hair today, gone tomorrow. No, a very serious question that I really want you to address, and you alluded to this problem in your remarks. So we have this phenomenon of judges, many of whom are elected, looking over their shoulders and, quite frankly, using bail as a tool to keep people in jail. My experience, many times, the thought that they have is, I want to set just enough to make sure that I don't get reversed if there's an appeal, a bail appeal, but enough to make sure that they don't get out. So here's the concern. As you transition into an evidence-based system, as Kenny pointed out, one of the features has to be the ability to detain people who are deemed a risk of flight or rearrest. What protections can you build in to prevent the judges who are going to have the same fears, the same concerns, once you give them this tool of preventive detention?
Yeah, it's a wonderful question. It is a kissing cousin with my admonitions. Don't be faked out into thinking the world's going to be safe for democracy if we all carry around risk assessments instead of bail schedules. Our justice systems have a tendency, as I said, to be mean-spirited, and you put another tool in the hands of judges, and this time you characterize it either as validated risk or protection of the community. We know who they're going to use it against. I think the federal system, the DC system, which requires a evidentiary hearing with loads of due process, that results in a surprisingly small percentage of defendants identified by the U.S. Attorney as eligible for detention. A surprisingly small percentage of them are actually detained. I think part and parcel with that for those who are, they have to run on a faster, speedy clock than those who are out. But first and foremost, I think there has to be adequate representation from the very beginning at that first hearing. It can't be a public defender with a pile of dockets on it. It has to be an attorney who has spoken to me for a second at least, who has an idea of who I am, what I'm charged with, and can do a competent and aggressive job of representing my hiney when I'm standing there. And unfortunately, that happens in this town. And if those of you ever get a chance to, if you haven't, go and watch court in Superior Court, that happens here. But you and I both know that it kind of sticks out like a sore thumb in its uniqueness of having adequate counsel and having a prosecutor who is dismissing charges at the first appearance and not waiting until 35 days later. And I've taught you a lesson now, I'll dismiss the charges. If I could just add one comment, because our moderator said we had tons of time. Another, and you brought it up, Norm, people use bail for all kinds of stuff, right? Bail's rarely. If the purpose of bail was to make sure I come back to court and stay out of trouble, and you were honest in administering it, money would be the last thing you would come up with to get me to do those things. Think about that for a minute, okay? And think about what we keep saying over and over and over. What does money actually do? Okay? But my detention serves a bunch of purposes as a pretrial defendant. You've sent a message to the community. You, as an elected judge, have taken a responsible act to protect our neighborhoods. You have insured. You're going to be able to manage your dockets and your caseloads, whether you're a public defender, a prosecutor, or a judge, because you know how compliant I am as a pretrial defendant. You know with certainty that when I'm chained together and I'm brought in on disposition day, you're going to get a disposition. It scares the hell out of me what I might say and do if I come in from home. And I love you, but the defense community is just as culpable as prosecutors and judges, for the most part, in this concern. I have had defenders tell me in public meetings, my clients are better off held pre-trial because I know they won't get into trouble and I know they won't fail to appear. The institutional imprint of how the current system works as having some rational and necessary basis is so deeply rooted. It isn't just about money, but we have to start with money. Once we tackle that beast, then we have a whole series of others, including who's getting arrested and all those other conversations that I know you'll come to. Sorry.
So one thing I wanted to follow up on Norm's point. There is a problem when you replace money bail with another tool and the same institutional concerns that judges have. I don't want to be that judge who releases the guy who rapes somebody else or goes back and kills the domestic violence victim. But the fact of the matter is, judges err on the other side to such an extreme that the system in place in D.C., for example, and the system in place in the federal system does at least require judges to document and state why they're finding that the person is a danger to the community and why they're finding the person is a flight risk. Without that justification, judges could simply take a preventive detention tool and say, yeah, I find that you need to be locked up. Just the way I found that $50,000 was just the right amount of bail to keep you locked up without saying that, right? That's how I set that number. And so there does have to be more than just the option to preventatively detain, because you run the risk of replacing one bad system with another bad system because you give them the same power. You just call it, instead of money, you call it preventive detention.
Can I ask a follow-up? The statistics in D.C. are terrific, obviously, but they're not so terrific when you look at the federal system, which has preventive detention, which I think the detention rate is close to 60%, even excluding people who are not in immigration status, which is shocking, really.
It is. And I think that the fact of the matter is, a lot of what we're finding is it depends on what you're charged with up front. The preventive detention statute works based on the charge. So if you are, for example, when I was director of the Public Defender Service, we had a case where a farmer from Iowa came to D.C. for some farm hearing. And he'd never been out of, Iowa before, and he, as he always does, comes in with his gun. He goes up to the Capitol, he puts the gun on the conveyor belt, and he goes through, and the marshals attack him. He's like, what? I put it on the belt, And that charge triggered a preventive detention. Someone who had no prior criminal record, no history of involvement. It triggered preventive detention, and he had to be locked up for 100 days until the case was resolved. So it took a lot of, speaking to the prosecutor, saying, "Oh, come on," right? It depended a lot on what you're charged with. So if your crime that the prosecutor decides to charge you with is a crime of violence versus basically a lesser crime that gets at the same conduct, they can trigger it, as they do in federal court more often, or they cannot trigger it by simply charging something different or not seeking preventive detention. So it is not just one bad actor. It's not just the defense or the judge. It is everybody on the front end of the criminal justice system making basically a paradigm shift and saying, we're going to look at this a lot differently. Bail is supposed to be a release-inducing system and not a detention-inducing system. And it's become very much a mechanism to detain people. And it's thought of as bail as a way to keep people locked up that we want to keep locked up, who are presumed innocent, as opposed to a way to release people who are presumptively innocent. And I think that's what needs to happen. And it's going to take more than one or two things to basically shift the mindset in the courtroom.
When you look at the variation among U.S. districts and you control for type of offense and defendant characteristics, you get to culture. I mean, you do. I know it sounds soft and mushy and all that other stuff, but federal courts have culture just as city courts and state courts do. And our very preliminary investigation of why do some districts have much higher release rates of the same guys than other districts goes squarely to the defense bar. Squarely to the defense bar. In some districts, when the U.S. attorney moves to detain, defense goes bananas and is very aggressive throughout the process. In others, quite candidly, they take it lying down and they're working for outcomes at disposition with limited resources. That's where they feel the biggest bang for the buck is.
And culture really is really the answer. The differences in D.C. and other places. That culture of release even extends to that initial that detention hearing. As I mentioned, 55% of the people that are initially detained get out. Have a higher rate of personal recognizance release at that second detention hearing as we do at our first initial appearance hearing. And it's because everyone in that system treats that second hearing as a chance for that person's release. Defense is there, the prosecuting attorney is there. We have a report to court again that stresses release if the court chooses. So we don't see that as kind of an automatic continuation of detention. It is simply another point in the process where release and detention ought to be considered.
I think we have a question right there. Ma'am, introduce yourself, please. Hang on one second. There's another microphone coming from this direction.
Don't break that one.
All right. Hopefully. Is that?
That's working, yes. Just speak up
Right.
a little.
My name is Emily. I'm a public defender in Virginia. And I wanted to ask about the bail review committee that Professor Jones discussed. And so if you have an organization that's really just lawyers, how do you do something like that? Do you try to partner with a university? I'm just curious sort of what kind of expertise is necessary and whether you have any suggestions for how to get that kind of a systemic review accomplished in an organization that has lawyers.
Yes. Well, I worked for the American Bar Association on what they call the Racial Justice Improvement Project. And we put together these racial justice task force groups where you basically bring together all of the people who have skin in the game, right? You bring together the prosecutor, the defense, the police, probation. You bring together all of the different actors and you form a committee. And you basically identify the problem. And what most of the jurisdictions did was then partner with a criminologist or professor at a local university. So in Duluth, Minnesota, of the 4 different sites we worked with, in Duluth, they partnered with a professor there who'd worked in the criminal justice system before. I mean, most courts have done some sort of statistical analysis and they use somebody at the local university. And the professor took 3 years of data from the court, looked at it, and he said, it is so obvious that this is going on. And that information coming from the defense bar would not have been received the same way. That information coming from pretrial would not have been received the same way. He said, I actually have no stake in this. I'm just telling you, according to your own data, Native Americans and African Americans are being locked up at a higher rate, even when the Native Americans and African Americans have no prior criminal record and the white Americans are on probation at the time of the rearrest. They're still getting out at a higher rate. And the judges just sort of sat there and listening to this information aghast, and everybody going, well, I know it's not me. And I thought to myself, well, there are only 16 judges in the jurisdiction. It's a few of you. In fact, it's most of you, right? So I think that the model that we developed with the ABA, and there's some reports out and there's a website on the Racial Justice Improvement Project, provided a good mechanism because all of the different actors in the criminal justice system got to weigh in. Judges got to say what reform they thought would work. And the procedure that they are employing now is actually collecting data at the bail hearing and then analyzing it. And what they've already found is just simply having a member of their task force group looking at the data, the judge is like, so is mine okay? I mean, so are you finding anything? I mean, let me know, because, you know, it is literally raising their consciousness, and I think they're making smarter decisions. We had one judge from the task force who went to a training conducted by Tim and Spurgeon, and he came back from the training at the National Association of Pretrial Services Agencies. And when he came back, he said he had a woman who came before him, a Native American woman, and she was charged with assault. And he said the prosecutor asked for, you know, $5,000 bail. And he said he was almost just about to, having been a former prosecutor himself, just reflexively say, yeah, $5,000 sounds reasonable. And he said he thought about what he'd learned at the training, that the purpose of bail was flight risk and community safety. And her father stood up and said, we live 100 miles away from this defendant, this victim. She lives with me. She doesn't have a car. I will get her back to court. I will make, if I have to tie her to a tree, her father always said, if I have to tie her to a tree, she will not come down and bother him. Please just release her to me. And the prosecutor was like, Your Honor, $5,000 bail is completely reasonable. And he said he thought, why would I give her $5,000 bail if she's not a flight risk and there's no risk of community safety? And he said that was his aha moment. And he released her with conditions. Stay away, stay home, report in weekly, and it worked. So, I mean, I think a lot of it is bringing together the people who are interested. If I was a lawyers group and I was trying to reform the bail system, I would get a partner with the court. I would get a partner with the prosecutor's office and bring those people together. And basically, when everybody agrees there's a problem, then you're just working on the solution and not sort of trying to convince them that something's wrong.
If I could actually add something to that, in Virginia, many of your jurisdictions have criminal justice coordinating councils or local criminal justice boards. The folks that Cynthia is talking about, in many jurisdictions, those folks are actually already meeting. The places where we've seen the most progress in criminal justice reform writ large in a county is a place where those folks are already meeting as a policy team, and they have some resources available to them for data analysis. And so many have criminal justice planners. Criminal justice coordinating councils have some staffing capacity. And if not, there is a master's student or a PhD student. This is simple math. This is not logistic regression or something more complicated than that I don't understand. This is really math. It's addition and subtraction. So if you have in Virginia, if you can partner with some of those criminal justice coordinating councils, go and offer to them to provide data analysis and provide that report to these councils that are already meeting.
And just to add to that, I think the amount of money we paid the researcher at the university was something like $2,000. We gave him the data from the court, which was the hard part, getting the data. It didn't cost him that much money. So it's not an expensive measure, and it was a good credential for him.
We have time for one more question. Who wants to be last? Mr. Rapping, you've been awfully quiet.
I think here we go. Right here.
Hi, John. Yes, sir.
Good morning. My name is Dr. Pryor. First, I want to thank NYU for hosting this, and I want to commend the NACDL for leading this and all of the partners that were part of putting together the report and today's convening. I actually have a couple of questions, but I want to just narrow it down to one, but I want to make a disclaimer because there's a part of the discussion that I think should be included. And that is that even before the bail determination is made, you have a person who's gone through what we know as bullpen treatment. That means that this person, has been detained for a day, 2 days, 3 days, depending on the jurisdiction. Unfortunately, I'm from New York City. Our mayor says, well, that's only a slight inconvenience. And I make that statement because there are a lot of people who think, like, what's the big deal? I mean, you only detain for a day or two, not realizing the impact and the trauma of those 2 days being detained. But even before it gets to bail, because bail only comes into play after the person has to either plead guilty or innocent. Because when you go through bullpen treatment and you come into the court and you're about to be arraigned, the question comes up, is this person, are you innocent or guilty? And what we have to realize is that after you go through 2 or 3 days of detainment, you plead guilty whether you're guilty or not. Because the fact of the matter is, anything that makes you believe you're going to get out, you're going to be able to walk out of the courtroom, is what you're going to do. And so what we're finding in many cases is that a lot of individuals will plead guilty if it's like a misdemeanor charge or a drug charge. I mean, they're not going to plead guilty to murder or anything of that nature. But individuals plead guilty believing they're going to get out, and then that guilty plea automatically locks them into getting a bail because it didn't work out the way they wanted to. And what I want to sensitize many of us to understand is that a lot of those guilty pleas is not because the person's guilty. That guilty plea comes as a result that I want to get out. I can't do another day in there because the conditions going through bullpen treatment is so severe that I want to get out. So that's just my disclaimer. My question is that no matter what tool you use, how do you ensure that the appropriate person gets the information they need in a timely fashion? Let's just say the judge, right? How do we hold the judge accountable? How do we prevent a judge from even being able to even have a discussion about bail or impose bail until we know for certain that they have the appropriate information, whether it be a risk assessment tool, whether they're using it, whatever they're using? How do we ensure that they get that information in a timely fashion and use that as a determining factor to impose a bail if that's going to be the outcome? Anybody? That question, anybody can answer.
Me, man. First and foremost, I think I have to convince you something's broken, right? I'm not going to be able to sell you a fix unless I've got you convinced, you the judge, you the prosecutor, you the defender, you whoever's paying for that bullpen. That's an important consumer. Sharice and I do a ton of work with counties because they're writing checks for those stupid places, right? And when you convince them how broken things are, their heads explode. Then getting system stakeholders, I don't think you can go after judges and expect to get anywhere. For the most part, they're elected. Let's say that they are, okay. And they are terrified that if they do anything, even when you can bring tears to their eyes and show them all the tragic wreckage that occurs from the current thing, and here's a bright, shiny way to fix it, it is foolish to expect them to operate in isolation. You're not going to get judges to go out on a limb by themselves. You can, however, by working with each of the stakeholder groups, get them to move as a group. And we're seeing, I hate to say anything optimistic because I've done such a great job of painting everything as being so terrible. And so I won't have credibility, but there are more and more and more jurisdictions that are coming together collaboratively, prosecutors, defenders, local government, law enforcement. Law enforcement, you guys, are you kidding me? We are up to our necks in cops who want to change a system where successful thugs who are dangerous get to buy their way out, and where low-risk people are becoming higher risk after only 2 or 3 days in the bullpen. I mean, again, look at those data. They are just breathtaking when you see Kenny and I are identical twins. He's out, I'm in. The only difference is I'm in, and my likelihood of recidivism starts to climb after only 1 or 2 days. And it's for exactly the kind of stuff you talk about. There is a reason. There is a list of reasons why prosecutors, who for the most part are God-fearing, diligent individuals, there are legitimate reasons for them to want bail to work effectively. It's not. There are defenders who have legitimate reasons. Every defender, every prosecutor have legitimate reasons for wanting this to work effectively, as do courts, as do cops, as do you and I. Create the demand among each of those consumer groups and then help facilitate them working collaboratively. It's like the bondsman. It's so much fun to villainize the bondsman. It's even more fun for me to villainize judges, but that ain't the deal. You know, we have to create systems in which it is the easiest thing for them to do to make the right decision, rather than the easiest thing to do is to maintain the status quo.
Great. Please join me in thanking our panelists.